He's been the agent for people, really noteworthy people like Mary Chicken Carpenter, worked for Harry Belafonte, done some amazing things as lawyer, producer, singer, songwriter. And the reason he's here today is his particular expertise on sound recordings, because he was the foundational director of Sound Exchange. And as we all know, sound recordings, which are distinguished from musical compositions, sound recordings, which are the embodiment of voice or performance from an instrument, only get digital audio transmission rights when it comes to public performance, a right that is both limited and subject to an amazingly complex statutory scheme. Perhaps the only person in the country who understands it is here. I'd also
There's
like
at
to
least 10.
Or 10,
There's
okay. But there's one more announcement I wanted to make. Is Mitch Stoltz, one of our BU grants, who works for the Electronic Frontier Foundation, has come to Boston to help with career advice for people interested in copyright, free speech, media, and related areas. People are free to come talk to him over lunch in the alumni boardroom at 12:30, and after that he'll be having individual advisee appointments. Mitch, would you wave? Mitch Stoltz. We are incredibly fortunate to have John Simpson coming to talk to us. I learn from him every time I talk to him, and I think you will learn a lot too. John, please.
Thank you very much. It's a great pleasure to be here. The last time I was on the BU campus, it was 1970. I was an itinerant folk singer, and in fact, a friend of mine had started a song that I ended up finishing, so we co-wrote it. More about co-writing later, but it was called Back Bay. And maybe I'll sing it from a few bars later, because I can direct license it and they won't have to worry about an ASCAP or license. But today we're going to talk about music performance rights, sound exchange issues, and statutory licensing. Me, 1971. Dropped out of Cornell University to sign a record deal, got sent to London, recorded with a lot of my childhood idols. I'm in Studio A during the day. Cat Stevens is recording East Train and Moon Shadow. I kept sneaking down there to watch him record because I thought that's real. You know, what I'm doing is just kind of, well, as was proven by history, I got so successful I went to law school. Though I did open for Jethro Tull on one act alone tour date in Albany, New York. I had a great high school band that I was in. My keyboard player ended up in Dire Straits. My lead guitar player ended up in a band that had a #1 record. We all grew up around New York City. Loving music. Anyway, today we're going to talk about music copyright, the basis of statutory licensing, the types of statutory licenses, rates and terms, Copyright Royalty and Distribution Reform Act of 2004, royalty allocation issues and payment, sound exchange, the collective, and a brief history, and the battle for performance rights. How many of you are familiar with the difference between voluntary licensing and statutory licensing? Just a show of hands.
Hey.
So understand that a statutory license is a taking of property, isn't it? It's the government saying to you, you have to license your property. So if a pornographic movie wants to use my song for my album in their movie, there's no compulsory license. It's a voluntary license. I have to agree to it, right? Because it's a derivative work license when we put my song in a movie. But if I set up a webcasting service and say, I want to stream music, I want to be Pandora, or digitally imported, or Slacker, or Rdio, I have the benefit of a congressional license that essentially gives me the right to stream anything I want, provided I do a few things. I have to pay, whatever the rate that gets set is, I have to pay. I have to provide data of what I'm playing so they can figure out who to pay. And there are certain other conditions. My primary goal in my streaming has to be streaming music. I can't be selling products. I can't be showing pornographic movies and having music kind of as a way to lure you in and or actually the movie's probably where you in. Music's just in the background. But, so there are definite conditions, we'll go over those in a little bit, but understand the difference between a compulsory license where I can't say no, and there's several of them in the Copyright Office. Music publishers can't say no once a song has been recorded, right? Everybody knows that if you want to record a Beatles song, you can do it. No one can stop you. The Beatles can't stop you. Prince can't stop you. He'd like to. Prince hates it when people cover his songs, so that is permission. But he can't stop you. Once a song has been distributed commercially to the public, anyone else can record it. They just have to provide 30 days notice and pay. But understand that there's a compulsion there. I can't say no. I have to do this. So the difference between a voluntary license where I can absolutely say no, which is why when you see political commercials and they use Tom Petty or whoever has said, no, please do not play my song with this political candidate, they have an absolute right to do that, right? And in fact, if you have strong feelings as a songwriter, when you sign away your rights to a music publisher, you better put in your contract certain restrictions, because if you don't, you lose your ability to say no. You've given over to the publisher the right to make these deals. So for example, if you don't want your song used in an R-rated movie or tobacco, alcohol, whatever the things that bother you, make sure it's in your contract. Or otherwise, when you've assigned those rights, someone else can exploit them. That's what happened to the Beatles with Michael Jackson, right? Michael Jackson owns the Beatles copyrights, their early copyrights. He licensed them to Nike. He licensed them to some other commercials. The Beatles couldn't say no. Now, the Beatles could say no, that they couldn't use the Beatles versions in those commercials. You ever notice that when you hear commercials of Beatles songs, In My Life, which is a terrible commercial, ruined the song, typically you will not hear the Beatles version. It'll be a sound-alike, or it'll be something that sounds completely different, whether it's Gomez or whoever else has covered Beatles songs. But understand the difference between compulsory, voluntary. Voluntary, I have control, I can say no. Compulsory, I have no right to say no. Now, when Congress passed the first performance right in the United States, it was 1995. First performance right for sound recordings. Musical work had been covered long ago. 1909 Act covers songwriters, other public performance of other media. But it wasn't until, anybody know when we got a copyright in sound recordings? What year? 72. Very good. By the way, 1971, November. I missed the copyright in my recording by 3 months. Makes me feel very foolish today. I should have had enough hindsight or foresight or whatever to have prevented the release of my record until February 15th of 72. But 1972, we get a copyright. Now, when we get that copyright, we don't get a performance right. Every other copyright has a performance right attached to it. Why not the sound recording? Anybody have any ideas? Yes?
The political power of radio stations.
The political power of radio stations. Good answer. And I will talk about this campaign that started in the 1920s and went to 1972, when record companies and artists finally got a copyright in their sound recording. The reason they couldn't get a copyright is that radio stations didn't want to have to pay the performers, the recording artists and the labels. They had to pay the songwriters because those rights were established in 1909 before radio existed. So in 1972, the record companies who were now becoming victims of bootlegging, of piracy, of people copying vinyl. It used to be the technology was too difficult, no one could copy vinyl. You didn't see bootleg recordings. All of a sudden we had the Bob Dylan bootlegs, we had the Neil Young bootlegs, and many other vinyl. No one bootlegged mine, by the way. And then, of course, cassettes made it even simpler. Not sure anyone would want to bootleg an 8-track tape, but anyway, because the record companies wanted the copyright to protect themselves from unauthorized reproduction and unauthorized distribution, they made an agreement with the broadcasters. Okay, fine, give us the copyright so we get our federal protection, and we'll take it without one of the basic rights of copyright. We won't have a performance right. So that's why in 1972, you finally got a copyright in sound recording absent a public performance right. Now, Was the record industry happy about that? No. They continued to fight for a performance right, as they had since the 1920s. Once we had a performance right, passed in 1995, took effect in 1996, then the question was, who's going to collect and distribute this money? You know, the other thing that I think is really important about 1995 and the campaign to get a full performance right, it ended up with just a digital performance right, is that it goes against the grain of so many people who over the years said, oh, the record industry was asleep at the switch and didn't see digital coming. Because this is certainly an evidence that they saw what was coming, at least in a limited way. No, they didn't see Napster and peer-to-peer. Clearly they didn't. But they did see the web with unlimited possibilities that you could have the All Madonna channel and the All Springsteen channel and all artist channels of every kind and shape, so that no one would ever need to purchase a record. So when they went in to get digital rights, one of the first things they went in to do was to limit how many songs you could play by a particular performer. They wanted to have playlist restrictions, essentially. They wanted to somehow control this new digital landscape that they saw. Now, they saw this as a possibility where there was going to be piracy. They didn't see peer-to-peer. So they wanted to prevent full albums from being played end-to-end because people would have digital copies. Little did they know that, 4 years after this act is passed, there were far easier ways to basically take music if you wanted to. So we'll see how anachronistic some of the provisions of this law are 3 years after it's passed and implemented. But they needed some way to collect and distribute this money. So SoundExchange was originally, the early money was paid for by the major recording companies, who obviously had a big stake in this. It was an unincorporated division of the RIAA, the Recording Industry Association of America. In fact, it was the RIAA who reached out to me in 1994 to get involved in the lobbying campaign to get the law passed, the EPRSA. I got other managers and other artists involved. And by the time we were done, there were about 150 major artists lobbying on Capitol Hill. And we got the law passed. So the RIAA was a very instrumental force in getting this law through Congress. Interestingly, the reason this law ended up passing is that none of the digital services that had any power were around at that time. So we were actually getting a full performance right. We wanted radio to pay as well. The broadcasters, with their infinite power, anybody know why the broadcasters are the strongest lobby in Washington? They do. Anybody know? Why do you think they're such a powerful lobby? It's not the money. They do spend a lot of money, but it's not the money. Access. In what way?
The people who are making the laws wanting it on those broadcasts.
People who make the laws need to be on the radio and TV to get elected. So if you're a local broadcaster and your local broadcaster doesn't like you, not a very good recipe for re-election. So the broadcasters have always had far more power than pretty much any other lobbying force in Washington. And you'll know, make a note of this, any time that the broadcasters have some issue in front of Congress, you will see those public service ads about when there was a disaster, people turned to radio to get information. They'll always talk to you. That's the public airways. We're doing the public good. They don't talk about the fact that they get the public airways for free, but that's a different issue. Anyway, so the broadcasters were such a powerful lobby that even though we went to get full rights, the light bulb must have gone off in the National Association of Broadcasters, their trade group, lobbying association. We can help the recording industry get this right against all of our future competitors. Great idea. So they did. So the broadcasters go in, and all of a sudden, rather than a full performance right, we end up with a digital performance right. Now, we knew satellite radio was coming. The SDARS, that was our acronym at SoundExchange, Satellite Digital Audio Radio Services, were Sirius and XM. We knew they were coming. They'd already gotten FCC licenses to launch their satellites, but they were still a glimmer. They didn't launch until 2001. There were 3 companies that did exist at that time, who these royalties were going to affect. And those were music services, music-only services that existed on DishNet and DirecTV. They were coming over the satellite or over cable to your cable service, and it was the blue screen music channel, the old school hip-hop channel, where you could hear your favorites. The album alternative channel, there was classical music, usually about 30 or 40 channels of digital music that were coming. There were three companies, DMX, Music Choice, and Muzak, who were in that space early. And because they were there in the early days, they received special treatment under the law. They're known as the PES services in our parlance, pre-existing satellite services. So the PES end up with a grandfathered rate because they already exist. The new satellite radio, again, they didn't exist. We didn't even know if they would ever launch. So that was sort of deferred in terms of what they're, but they did get a special rate standard, which we'll talk about later, these satellite radio services, different than webcasting. Webcasting at the time, there was really only one major person who was in the webcasting space. It's hard to describe this individual, but you've all seen him if you watch basketball, sitting on the sidelines of the Dallas Mavericks. Because he started something called Broadcast.com, and before the dot-com bubble, he sold Broadcast.com to Yahoo for $4 or $5 billion, and which enabled him to buy an NBA team, and Mark Cuban was the guy. And very, Mark Cuban blamed the rates that we were setting in webcasting for 9/11, among other things. I mean, it's pretty nonsensical stuff, pretty dramatic. But Mark Cuban, because he had this service while this law was going through, wanted to make sure of one thing, and one thing only, that whatever rights the record companies and artists got was that it was compulsory. He didn't want the record companies to have the ability to say, no, we're not going to license your service. And that is why the rights under Section 112 and 114, 112 being the ephemeral license that goes along with the Section 114 sound recording license for digital, are compulsory. There was one other group of people who wanted to make sure it was compulsory. Anybody have an idea who it might be? Who else would want it to be compulsory? Who's that?
The artist.
The artist. Oh, interesting. Would the artist, probably so. The artist wouldn't want the record companies withholding because the artist would just want the money. But there was actually another group that had a stronger interest in making sure it was compulsory. What other lobbying group in Washington would have slightly different interests than the recording artists or the labels? Who else is collecting money when music is being performed? Yeah. Oh.
The collective rights organizations.
The collective rights organizations, ASCAP, BMI, and CSAC, who are representing songwriters. So imagine you're running one of those PROs, your members are songwriters. Now many of them overlap. There are many songwriters who are also recording artists. But there's plenty of songwriters who aren't. What happens if here's a brand new service, we want to make money, and the record companies refuse to license? They can stop your ability to make money. So the PROs were in the room at the same time that this legislation was going through Congress, saying, we want to make sure that it's compulsory so that they can't stop the ability of people to license and for the use of the music so that we end up making money for our songwriters. That's why we ended up with a compulsory license. And you could well imagine that if this had been a voluntary license, webcasting would be very different than it is today. In fact, probably wouldn't exist if it weren't compulsory. The transaction costs would have been so high because if it's not compulsory, you have to go to every single rights owner to get your rights. Now remember, within streaming music, how many of you guys listen to Pandora? Show hands, okay? How many people listen to Spotify? How many people listen to both? Spotify is fundamentally different than Pandora in what way? Yeah.
You can control what song you're listening to and when.
You can control what song you're listening to and when. So it is an on-demand service, right? Because it's on demand, it cannot take advantage of the statutory license that Sound Exchange has. So it's an on-demand service. That means they have to negotiate with every single rights owner. Does anybody know how long it took Spotify to launch in the United States? Anyone have any guesses? Was it more than a year? More than 2 years? 3 years? It was about 3 years. And you know what else happened? Spotify had to give 20% of its equity to the major label companies. So the three major labels ended up owning 20% because they could extract that out of Spotify because it was a voluntary license. Pandora had to give away no equity. though they might have offered some, but we won't go. Pandora, interestingly, and for those of you who haven't read the definition of what's a non-interactive versus an interactive service in the statute, in section 114, read that. And it'd be interesting to find out, you could send me an email, whether you think Pandora, by that definition, is an interactive service. I had a board member at SoundExchange who claimed he wrote the definition, and Pandora was certainly an interactive service based on what he was thinking when he wrote it. That doesn't really matter. Pandora has utilized the statutory license, much to the chagrin of the record companies in the early days. Now I think they've just sort of accepted it. There was a case in New York, the Launchcast case, that essentially pushed the line of interactivity from user-influenced, personalized, to on-demand, the song you want when you want it. And since that time, you know, the battle over whether Pandora should have a statutory license or a voluntary license because they're interactive, pretty much gone away. So we have, wow, that's a lot louder. I just switched on my mute button. No. So in any event, Pandora has been an interesting service to watch because it is a market leader, and because arguably some of the labels still feel that they cross the line into interactivity. So back to SoundExchange. It wasn't individually incorporated until 2003, moved out of the RIAA as an independent trade association. And essentially they were moved out of the RIAA because the RIAA represented only the major labels, a few independents. But they didn't represent artists, and the artists wanted SoundExchange to be free and clear. The RIAA originally went to ASCAP and BMI and said, you guys already run collecting societies, why not just collect the money for us? Save us the money of having to build something. If you already do this, I think it would have been a huge mistake if that had happened. And I think what ultimately was determined was that there was an inherent conflict. That every time ASCAP or BMI would go to Congress, go in front of an arbitration panel, or some other rate proceeding, set rates for recording artists, it would be seen as money that was coming out of the pockets of songwriters. And so it would be very tough for them to be advocates in the same way as an independent organization, which is why ultimately ASCAP and BMI were not given the task of running SoundExchange. But it was certainly considered in the early days. SoundExchange is a 501c6, and it's controlled by a board of 9 members, artists 9 members, copyright owners. Interestingly, how many of you have ever seen the 990 for SoundExchange? Anybody ever bothered to look? Because it's public. You can see exactly how they spend their money. You can see what the executives make. You can't do that for ASCAP and BMI, even though they're nonprofit. SoundExchange is completely transparent in so many ways. CSAC is a for-profit company, the third PRO, so very private. You don't see any information. The only way you get information about CSAC is if you're a venture capitalist looking to buy it. And then you might get some data and information. A much smaller organization, CSAC, than ASCAP or BMI, also much smaller now than SoundExchange. So SoundExchange is created. Initially, my board was 9 labels and 4 artists because we were created by the RIAA. My mission then was to build out the board when I took it over to be equal, but it wasn't entirely equal. And one of the reasons is the basis for the licensing of transmissions. When you as an artist sign a contract, you typically give your record company the right to license your work. Some artists withhold that license. That's why the Black Keys aren't on Spotify, because the Black Keys, when they signed their record, they said, we want to control the licensing of our work. That's why the Beatles control the licensing of their work. And other major artists have had the ability to essentially say no to some of these digital services because they control those rights. But typically, you have a grant of rights to the record company to control licensing. So the record companies always were the dominant force on the licensing of the SoundExchange board. They had more of an interest in it, frankly, they had more experience in it. And, you know, they were going to demand far more than the artist would. Having been an artist, I can tell you, you're always worried about asking for too much. Although you might not like me if I ask for too much. It's the nature of being an artist. It's why you always want to have an agent. Because the agent can ask for too much. And in fact, I invented an agent for myself at one point who had a British accent. It was really kind of fun. It worked. I always got more money when I came on as my agent as opposed to myself. Sound Exchange is not a membership organization, though we do, or they do refer to people who sign up as their members. Now, back to some basics. You guys know the difference between the C in the circle and the P in the circle? Show of hands.
There's music people here as well as lawyers.
Oh,
so
okay.
they don't know.
Good. So every sound recording that you hear has 2 copyrights. Well, 2 copyrights 90% of the time. There's the composition, the song that was written. All right. Illustrations, huh? We have visual aids here. Okay. So, if I do, here we go. All right, what song are we playing? Blackberry, okay. So, Lennon and McCartney own the copyright in that song, right? Now, they do not own a copyright in my version. Blackbird singing in the dead of night. Okay, there we go. They don't own the copyright in my version. Thank you. Boston University, on the release form I signed, owns that version. Or I own it until I transfer it to somebody else. So, C in the circle, the composition owned by the composers until they transfer it by written agreement to a music publisher, typically. We'll talk more about that later. And then there's the P in the circle, and that's the phono record. That is the actual recorded version. So if you think about Gotta Get You Into My Life, another Lennon and McCartney composition, Earth, Wind & Fire recorded, had a big hit with it. Lennon and McCartney still own the C in the circle. Michael Jackson owns their publishing, so he owns the C in the circle. But the P in the circle of the Beatles was EMI. The P in the circle for Earth, Wind & Fire was Sony. So different people can own the sound recording copyright of the same song. The authors typically stay the same on the composition side. But interesting to make sure you understand 2 copyrights. Now, there are 2 situations where you would only have 1 copyright in a recording. Anybody figure out what they might be? Where would you only have 1 copyright in a recording? All right, think about my album.
Hands.
Oh, hands, yeah.
Oh, I was gonna say if the song itself is in the public domain, but.
Correct.
Yeah.
Okay, so song in the public domain, no C in the circle, it's in the public domain. But if I record it, I have a copyright in my recorded version of that. Second, you know what the second incidence might be of only 1 copyright? Yeah?
Where there's no composition?
No?
Just in your recording sound?
No. So we've already got the composition, it's public domain.
Right, where the sound recording doesn't actually have a song or composition.
Oh, I see what you're saying, where it's like ambient sound that you couldn't get a copyright in. Very interesting point. That's probably another place that I hadn't even thought about. Good point. But there's a third one where it's the P in the circle that goes away. Jenny, any ideas where that might be? What? Yeah.
Just written music? Is that just written down music? Is that what they're?
Well, no. If there's a recording and you're listening to it on the radio, it might only have a composition copyright. Why wouldn't it have a P in the circle copyright for the phono record? What if it was my album? When did it come out? 1971. Anything pre-72 does not have a P in a circle in the United States. Now, in Europe, they have a P in a circle, and their term of copyright is actually shorter than ours. But we'll get into that maybe later if we have some time. All right, so 2 distinct copyrights for every song, except in those situations. And remember, to get a copyright, things have to be fixed in a tangible form. All right, so the traditional rights of copyright owners, the public performance of the work, reproduction and copies, distribution, and sales. 17 U.S.C. 106, that's where you find it. And as we talked about, the sound recording does not have a full performance right. So what that means should get key here. For a number of years, I was fortunate enough to be a business advisor to a living legend. One of my childhood idols, I finally got to work with him on a number of projects, and every time I would go to a baseball stadium, a football stadium, a basketball, I don't go to basketball, so not do basketball, watching on TV, I would hear, Dale, Dale, you know, right? Harry Belafonte, wonderful recording artist. Every time a baseball stadium would play that, he would get zero, nothing. Right? The songwriter would get paid because there's a public performance right for stadiums, for bars, for restaurants. There is no public performance right in stadiums, bars, and restaurants for the sound recording for Mr. Belafonte's performance. That was always annoying to me. It would always drove me crazy that you go into a restaurant, they play music, the recording artist gets zero. Are they really promoting the career of the recording artist in the restaurant, or are they playing background music so you'll stay longer, drink more, eat more, have a great time? You know, it's interesting, my counterpart who ran the Dutch Collecting Society, where they have full rights in the Netherlands, as there is in most of Europe and the rest of the world, recording artists are protected everywhere their songs are played. Doctor's offices, dentist's office. And of course we know that music has value in dentist's offices, right? Because they can either play more Kenny G or give you more Novocaine. It's like, anyway, he found out that a farmer in the Netherlands was playing music to his cows because they produced more milk. So he went and licensed the farm. And he was able to collect money because they were using music in a business. Everywhere else, that's what happens. In the United States, no. We are limited to digital, non-interactive digital transmissions. No rights in clubs, no rights in bars, no rights in restaurants, no rights on over-the-air radio or television. Now, in the United States, composers have the option of joining one of three organizations: ASCAP, BMI, or CSAC, for public performance. In the United States, there's only one organization on the sound recording for public performance, Sound Exchange. What do you guys think? Is that better for recording artists or worse? Competition. What do you think? Is it better or worse to have one organization or to have many? Anybody have any thoughts about that? Yeah.
Well, I think having one probably has its advantages because it makes it easier for people to get the licenses for everything. They only have to go to
One
one
place.
person.
Right.
On the other hand, they could keep the prices artificially high because there's no one else to go get licenses from.
Very good. Very well stated. The other piece that I think some people would argue is that with ASCAP and BMI, the competition between them provided that they would have to be nimble because they were competing. That somehow they would have to, try to offer some advantages. And in the past, well, let me give you a little history, and that may be helpful. Sound Exchange exists by itself. It has an antitrust exemption in the statute that created the performance right in 1995. Not by name, but it just said that there could be a collective organization to represent all of the owners of content. On the musical side, on the musical work side, those rights started, again, in the 1909 Copyright Act, granted songwriters the rights. ASCAP started in 1914, and they were started by the major composers of the day. John Philip Sousa, the heirs of Stephen Foster, the Gershwins, Cole Porter, Duke Ellington. You had a lot of, serious composers, mostly based in New York and Chicago. ASCAP was essentially a monopoly in its early days. And primarily, their revenues came from movie theaters. They were collecting, I think, about 10 cents a seat per year in all the movie theaters. That got changed in a Supreme Court case somewhat later. But in the early days, it was movie theaters that generated the money and some public performance in bars and restaurants. But the big battle that ASCAP faced in the 1920s was against the broadcasters. Radio starts in the 1920s. And radio stations are then, they have their first ad on the air in 1922, and ASCAP says, we should be going to collect that money. That's a public performance of recordings. They're making money because they're running ads. They go to radio stations and say, pay us. Radio stations say, no, we don't think we should have to pay you. ASCAP says, yes, you do. Here's the copyright law. Broadcasters respond in 1923 by forming the National Association of Broadcasters as their trade association. And they go to Congress and they try to get a law to outlaw ASCAP. And then they try to get the Justice Department to shut ASCAP down in 1924. And they fail. So ultimately they start paying for the compositions that they're airing on the radio in the 1920s. Fast forward to the 1930s, ASCAP is collecting about 5% of revenue from radio. And they want to escalate that rate to 7.5%. The broadcasters get very upset about this. And so they say, we're going to set up our own competing society to compete with ASCAP and bring the prices down. We're going to set up BMI, Broadcast Music Incorporated. And BMI was started in 1940. Now, if you were a songwriter, composer, publisher, why would you sign with the broadcasters instead of a collection, an unincorporated society of your peers, of composers, authors, and publishers who ran ASCAP? Anybody have any ideas? Yeah?
They'd probably be able to get you more exposure if you were new.
You know, there could be the claim that, hey, if you sign up with us, we are the broadcasters, we'll play you more. It's a claim that's made frequently. That's partly true. Anything else? Anybody have any ideas? Yeah.
I was thinking, maybe it was easier to go through them, or cheaper, or something.
Well, it wasn't easier or cheaper, but, well, actually it was easier. One of the problems with ASCAP in the early days, because they were started by the Tin Pan Alley, the New York-centric composers, was hillbilly music. They completely denigrated. Oh, it's just hillbilly music coming out of Nashville. And they completely denigrated what was called race music at the time, coming out of Memphis, and coming out of other parts of the South. So blues music, country music, ASCAP was completely ignoring. So the broadcasters realized they had an opening. So they started signing up these artists because the artists really couldn't go to ASCAP because ASCAP wasn't paying them at the same level they were paying. You know, their songs were more popular, these new blues musicians, these new country musicians. These were the popular songs of the day, and yet ASCAP was skewing their payments toward their initial members. That was, by the way, a great learning lesson for me at Sound Exchange when I launched it, which was to be all-inclusive, to be completely transparent, and make sure everybody got paid. And it's helpful that you have a statutory license because you can't help to pay everybody the same. There's a statutory license that says, here's the rate that everybody gets paid every time their song gets played. So BMI gets launched because of ASCAP's elitism and their lack of inclusiveness. And just to give you an idea of what the transition was like, in the 1960s, late 1960s, when I was in bands and looking to affiliate as a songwriter, a lot of my friends thought BMI stood for Black Music Incorporated because every black artist was on BMI. I mean, that's how pervasive it was. Now, ASCAP and BMI are essentially the same in terms of they each have repertoire in all the different genres, and they essentially each have about 48% of the compositional repertoire in the United States. So together, combined, 96%. CSAC has about 4% of repertoire. But it's very interesting to understand that history because what also happened with BMI coming into the marketplace to compete was radios from 5% now pays 3.5% to 4% of their revenue. So prices did come down because of the competition. Competition brings prices down. Great for the users, not great for the songwriters. Now, one of the things BMI has done, because they are run by the broadcasters, is be more aggressive on other licensing types, whether it's clubs and bars and restaurants, or new media, or other places where music is used, to essentially distract from the fact that when it comes to radio payments, you know, they're not going to be as aggressive to try to drive rates up as ASCAP will be. Anyway, one of the things, because of their market share and potential for abuse, there is a Department of Justice consent decree with both ASCAP and BMI. And essentially what it says is that any user can, if they're not happy with the rate they get offered, has the ability to go to a rate court proceeding. And that rate court takes place in the Southern District of New York. And there's one judge who is dedicated to this rate court. And so essentially, because of this consent decree, it's kind of like a statutory license, where the way Congress created Sound Exchange, our statutory license works this way. We have a period of time to enter into deals with users, and they're all lumped in categories. If you are this kind of a service, you get this license. If you're this kind of a service, you get this license. And you can pick whichever license you think fits your service. So we have a bunch of different statutory licenses. So Sound Exchange enters into voluntary negotiations for 6 months. And if those voluntary negotiations fail, then we go into something used to be called a CARP. And I think you were involved in one of the CARPs, is that right?
No, only in the CRB.
In the CRB, okay. So the CARPs, and it was very good that the royalty panel was at the end and not copyright royalty arbitration panel, because that would have been crap. But most people thought that's what the results were. We started out arbitrating rates in front of 3 private arbitrators. In Congress's infinite wisdom during the Clinton era, they got rid of a copyright royalty tribunal, which was 3 judges who decided all these copyright matters. We got rid of them and said, all you parties can pay for private arbitrators. And these arbitrators typically cost in the millions of dollars. The effect of that, of having to pay for arbitrators, was that small services could not participate. Because they just knew they couldn't afford to pay their relative share of $1 million fee or $2 million fee. So it discouraged small users from getting involved. It was always the big services on both sides. Now, I will say from our perspective at Sound Exchange, we always included the independent labels, the smaller artists and independent labels, because we realized they were a very important part of our story. So we included them. On the broadcast side, the user side, frankly, I think Mark Cuban was the one who said that when Yahoo negotiated its first deal with URAA, he was trying to set a rate that was high enough that he put everybody else out of business. He wasn't going to help the little guys get a rate that was good for them. He was getting a rate that was only good for himself. It makes sense, it's in business. But those early arbitration panels were very difficult and led to a lot of dissent by smaller users who said, we can't participate. Congress passed a law in 2004 taking us all the way back to the Copyright Royalty Tribunal with a new name called the Copyright Royalty Board, made up of 3 judges, copyright royalty judges, who would now hear these disputes and set statutory licenses. Again, 6 months to negotiate a voluntary license. If we couldn't do that, we went into a major litigation with all of the services that were interested to set rates and terms for what people would have to pay when they streamed music. Again, ASCAP and BMI, their situation is not that different. If they can't reach agreement with certain categories of users, those users have the right to go to rate court in the Southern District of New York. But it's not identical. You understand that the consent decree, while it forces them to license, doesn't really give it quite the same. And I will tell you that the rate results we've gotten from the Copyright Royalty Board have been far superior to the results they've gotten in the Southern District of New York. So as I mentioned, the sound recording copyright, public performance right, we are not paid for terrestrial broadcast of our sound recording, so radio stations have the complete right to play without paying. Now, when the broadcasters helped us get these rights in 1995, they actually grandfathered in their own HD radio broadcasts or digital audio broadcasts. That would be exempt, even though it looked exactly like webcasting, even though it looked exactly like satellite radio. They were the broadcasters. They get what they want. So they had an exemption. The only time they would have to pay in their initial, in the initial statute was if they charged a fee. If it was a subscription, if you had to pay for this new digital audio broadcasting or HD radio, you would then have to, they would then have to pay a fee to the record labels and artists. Now, I talked a little bit about non-interactive versus interactive digital transmissions. Sound Exchange only looking after non-interactive, but as we've seen through case law and other developments, essentially, yeah.
Could you explain in 114 where these limitations come from? For example, why would a terrestrial broadcast that was digital not trigger an obligation to pay? I mean,
Well,
all
in
up 114, 17 USC 114, just by typing it in.
but that computer's offline. I'm sorry. But you have it in your hand, don't you?
Yes.
Um,
If you could guide people through that, would be really helpful.
Yeah, okay. You can see that in your handout on page 3, limitations on the exclusive right, it says exempt transmissions and retransmissions. And if you look at D1B, a retransmission of a non-subscription broadcast transmission. So again, the radio station is not charging a fee, so it's non-subscription. And it's broadcast transmission, and if you look in the statutory language, you'll see that that's an FCC licensed broadcast transmission. Now, there is a very interesting clause in here which was the subject of a federal lawsuit in 2003. The broadcasters say, we're exempt, and it's clear that these exemptions cover high definition or digital audio broadcasting. What was unclear was whether, when radio stations started websites, and clearly in 1995 they were not thinking that far ahead, that they might at some point be streaming from websites. So that is much murkier in the statute. And if you look at it, it says, provided that in the case of a retransmission of a radio station's broadcast transmission, the radio station's broadcast transmission is not willfully or repeatedly retransmitted more than a radius of 150 miles from the site of the radio broadcast transmitter. So what ended up happening is they realized that you couldn't actually limit that. And that was the basis for the Register of Copyrights issued a ruling in 2002 that broadcasters, when they simulcasted their signal, simulcast meaning the same exact programming over the air goes online, they had to pay. And they were very upset. So they sued the Copyright Office, Bonneville versus Peters. Bonneville radio broadcasters sued Mary Beth Peters, the Register of Copyrights. And they lost. I think it was a Third Circuit case. Take a look, it's very interesting because, you know, if you read the statute, it seems that they said, well, all of our listeners are within 75 miles of the tower, but that's not true, or within 150 miles. Because a lot of people, you know, they're away and they're yearning to hear their hometown radio station because they're missing the 12 minutes of commercials every hour, I don't know. You know, we're listening in. But the ruling of the court was essentially, you can't control how these are repeated and how far they actually go, therefore you're going to have to pay. And the broadcasters started paying in 2002, well, retroactive 2002 based on this decision by the Copyright Office and then by the Third Circuit. So it's now settled that broadcasters do have to pay when they stream from their website. And the simulcasters, very interesting, we'll see what effect that's had. We now have some private deals in the marketplace because of that ruling. Another important thing to remember is Sound Exchange license that it administers. And remember, Sound Exchange doesn't grant the license. The government has granted the license. Congress passed this statutory license. Sound Exchange just administers the license on behalf of the copyright owners and the artists. It's important to understand that this is an audio-only transmission. As soon as you have audio-visual, if you see videos on YouTube or if you see videos on any site, Sound Exchange does not cover that. It is not covered under statutory licensing. That is an exclusive license, again, a voluntary license. It has to be entered into by whoever owns the video and the service that's showing the video. We've seen that the record companies have actually partnered. They have a service called Hulu, they have another service called Vivo. Obviously, they're all dwarfed by YouTube, and there have now been deals made with YouTube with regard to streaming videos, and now some subscription service I see is coming on YouTube for certain content, and it'll be interesting to see if people will pay, because people are so used to getting anything on YouTube for free. Now again, it's sort of the radio model, you pay by attention. Because if you've noticed that pretty much more and more videos on YouTube, to see them, you have to sit through the video pre-roll, right? 10 seconds of commercial, 15 seconds of commercial. So they know that if you want to see this video, you have to sit through, and we make at least a little bit of money. And as you can well imagine, if you're sitting through a particular video, there's some sense that there's a much more targeted audience, and the amounts that advertisers are willing to pay for those targeted ads is more. So it's a more valuable ad, and they pay more for it. Anyway, Sound Exchange has administered this license, and the key is users aren't required to negotiate with individual copyright owners. They can. Remember, a user is always free to go around Sound Exchange and direct license, right? Even though Sound Exchange has an antitrust exemption built into the statute, one of the other safety valves, other than the fact that the rates are set by a congressionally authorized body when there's no agreement on rates, is that every user can go around Sound Exchange and make thousands and thousands of deals if they want to. And frankly, if you were a service that was only going to use major label recordings, you really only have to make 3 deals now. There are only 3 companies left that own about 70 to 80% of the valuable content. So it's very easy to make a deal with three companies to get 80% of what you need. It's the last 20% that is very difficult. It's tens of thousands. I think Sound Exchange now has 28,000 rights owners who own content who are members of Sound Exchange. So 3 major labels, 27,997 independents. You know, it's kind of the way to look at it. And even then, you're taking a risk if you go around. Remember, you use the statutory license, you can't be sued. No one can sue you and say, you didn't have the right to use my recording. No, it's an absolute protection if you use the statutory license that Congress gives you. As soon as you go around Sound Exchange and do direct licenses, you are running the risk that you're going to play something that you didn't properly license. And that copyright infringement case can be worth lots of money. You've probably talked about copyright trolls. I mean, they exist in this business, and some of them are very oppressive, and it's not fun. One other thing that is...
Say just a minute more about that. That is, patent troll usually means someone who's not using his patent, but sues people who have inadvertently done something that might be considered an infringement. How would you define a copyright troll?
Okay, so there's several. The ones that I run into represent clients. A friend of mine is a performer. He has a website. He has people doing website design for him. And they found a public domain image. And they put the public domain image on his website. A year and a half later, he gets a notice from a company saying they've been using their image for a year and a half. Of course, they didn't tell him 30 days later or 60 days later. They waited a year and a half because the annual fee was $2,000, and he now needs to pay $3,000 because he's been using their image. What was happening was there was a photographer going around and taking photos of public domain images, and then sometimes you would see the notice on the bottom that it was actually copywritten, other times you wouldn't. And yet they would have it watermarked in some way to show that it was this photograph of a public domain image and not the actual original image. And typically these people are relying on the fact that you're just going to pay to get rid of it, that you're going to make it go away. I said to this client, I said, look, if you hire me, you're going to pay me far more than you're going to pay this person, but I'm sure you can get the fee down a lot lower. And actually I put them in touch with the IP clinic at American University at the law school, and they agreed to represent him, and I think he ended up paying $500, which finally was just nuisance to go away, to put it behind him. But this was really offensive to me, that someone was doing this. It's not quite as offensive, some of the ones that are a little murkier, or like almost like an orphan work, where you can't find the owner. Maybe you haven't done a very good search to find the owner. But we've also seen lawsuits where someone has licensed 1 million tracks. There's a company called MediaNet that licenses tracks to then be able to go to services and say, we've licensed all these tracks, you can use them. And MediaNet has made a few mistakes. where, oh yeah, they had the sound recording license, but they actually didn't have all of the songwriters who had written the song. They didn't, and it wasn't an ASCAP or BMI license or CSAC license that covered it. And all of a sudden, the publisher came forward and said, you owe us a lot of money because you willfully infringed on our copyright. So you do have some areas where some of them are very abusive, some of them are probably just negligent. And there's a couple of things that this points out. And it's one of my biggest beefs with the music industry. Okay, so big picture. Let's take a look at the big picture for a second. When Congress passed the law creating this compulsory license, that anyone could stream anything they wanted. The fascinating thing when you think about it, and then they said to this organization that I ended up running, you have to go out and find all these people and pay them. There was no requirement that they had to come sign up with me to give me all their information. How did I know who I was going to look for? You know, I mean, the Beatles are easy to find, or their business managers, their lawyers. You know, Bob Dylan's easy to find. Outkast is easy to find. You know, I mean, there's a lot of people, it's easy to find them. But try finding an artist who hasn't put out a record since 1947. You know, and that was the job I was given. And, you know, and we're talking now, you know, it's one thing, fine. How many of you listen to over-the-air radio? You know, where they play the same 30 songs over?
Less than 30.
Up to 20, maybe 15, where they pay Katy Perry every 30 minutes. Now it's Miley Cyrus every 30 minutes. Online, you know, you think about the breadth of what gets played online. I mean, I was actually getting reports from services in Cyrillic. I was getting some reports of use in Chinese characters. You know, we looked at this stuff, it was like, who are we going to pay here? You know, I better bring in some people who know how to read these characters. But you started to realize, yeah.
I just have a quick question. You said if someone hasn't reported since 1947, but would that have, that was pre-72?
Pre-72. It's a very interesting question. Does someone who records a pre-72 recording get paid under a statutory license? They don't have a copyright in their sound recording. They clearly can, whoever wrote the song will get paid because the composition is protected. But Sound Exchange actually was a creature of government regulation as well. The Copyright Office had issued regulations about what Sound Exchange was supposed to do to essentially put in force these laws. And one of the regulations is that we were supposed to pay out the money based on what was reported to us as being played by these services. Now, a service could technically take the position, hey, wait a minute, there's no federal protection of the pre-72 recording, we don't have to pay for this, and not pay us at all, and not report it to us at all. But as soon as they reported it, they had an obligation to pay for it under the Copyright Office regulations. You couldn't report but not pay. Because it made our job way too complicated to go, oh, this doesn't get paid, this gets paid, this doesn't get. So you only send us stuff that you owe us money for, and only pay us for the stuff you owe us for. And so we would, you know, and in addition, the very first 5 years of satellite radio was a private deal where they agreed to pay for everything. They had a 40s channel, a 50s channel, a 60s channel. And then we would just pay it through to all the people who got to play it. But it's a very interesting question, and we always took it very seriously. We didn't think it was likely that artists from the 1980s would sue Sound Exchange and say, you shouldn't be paying these artists from the 1940s or 50s. I think politically it wouldn't happen. But we now are seeing some of the services saying, we're not paying you for those services. And we'll talk about that at the end, the litigation that's now going on between SiriusXM and satellite radio service. Yeah.
Variation on Professor Dogan's question. Let's say you have a 1947 piece of music by a resident of, let's say, New York, which recognized a common law copyright either under the name of right of publicity or under the Metropolitan Opera case. They may say that they have a performance right and that they are not subject to the compulsory license because they have something special that Congress didn't mean to embrace within the compulsory license. Therefore, everybody's violating their copyrights who thinks they have a compulsory license but really don't.
That is a really good point that, again, was discussed internally quite at length, which was, is there a common law right? I mean, have the ruling, you mentioned the Metropolitan Opera case, you have the Fred Waring case against WDAS in Pennsylvania. You had the Paul Whiteman case, which then was RCA Victor versus Whiteman. There are a number of cases that have held that there are common law rights and state law rights that may attach to these recordings. Sound Exchange's position was, look, we have regulations from the Copyright Office. It tells us to pay out on everything that's reported to us and paid it. And that's what we did. The interesting issue here is that now we're getting into the lawsuit with SiriusXM. They did stop recording and stop paying. And they said, and if you think about it, it's a lot of money. SiriusXM will probably pay Sound Exchange this year about $300 million in royalties. About 15% of their repertoire is pre-72. That's $45 million. It's not a small amount of money. They are saying under the, and in fact, in the most recent Copyright Royalty Board ruling, the judge is saying pre-72 recordings are not covered. It was the first time we actually had an official ruling by an official body saying there is no obligation to pay for these under the federal statute. But it brings up Wendy's point, which is there may be a state obligation to pay or a common law obligation to pay. And there have been 2 lawsuits now filed. SiriusXM has stopped paying. The Turtles, Flo and Eddie. You all remember the Turtles. Imagine, yeah. Okay, anyway. Turtles filed a lawsuit in several states now. And then the major labels, because I don't think they wanted to be wagging the turtle's tail. The major labels filed their own lawsuit in California. So there's 2 litigations going on right now, and frankly, there's at least 2 or 3 more being contemplated by other class action law firms who've been trying to round up some plaintiffs, some appropriate plaintiffs. And the hard part, and I mentioned this earlier, is that when you sign a record contract as an artist, you give your rights to license to the label. So if you were on one of the major labels, or a label that's been acquired by the majors, and again, that's 70 to 80% of the stuff, might even be more for pre-72. I mean, my record's a really good example. I was on a small independent label called Perception Records. They did have Dizzy Gillespie and James Moody, some good jazz artists. They had 1 hit by a group called King Harvest, Dancing in the Moonlight. And my record, of course, which was massively successful. It's a collector's item. And when Perception went bankrupt, their assets were bought by a company called Sanctuary. And when Sanctuary went bankrupt, their assets were bought by Universal. So I ended up being on Universal Music. I was on a major label. It was really exciting 40 years later. But that's what happens. Universal actually just sold my recording and the entire Perception catalog to BMG. So you have a situation where you now have these lawsuits filed against SiriusXM. You have a separate lawsuit filed by Sound Exchange that's actually not related as much to the pre-72 issue as some other issues that Sound Exchange had with SiriusXM. And here's the real, I think, the very huge risk that SiriusXM took. For the last 10 years, Sound Exchange has been accepting their money, paying it out to all of the people who've been getting play, including the pre-72 recordings. Now that they're not paying for pre-72, when the Beatles go in there, or EMI on behalf of the Beatles, win, if they win. If they win, there is a common law or a statutory right in California or in New York to have to pay. There's no compulsory license rate. The compulsory license rate right now means Sirius has to pay 8% of their revenue. And it's 8% escalating to 13% over the next 5 years. Beatles are going to go, we want 25% of your revenue. Right? I mean, this is the most valuable stuff that's ever been made, arguably. Motown, right? I mean, you think about these classic catalogs of music that were made in that period of time. They're going to be asking for 25%, 30%. And there's precedent for that. You know, as we'll talk about some of the statutory rates in a minute, Pandora has a rate with Sound Exchange that's 25% of their revenue, or a per stream rate, whichever is higher. And the effective rate Pandora is paying right now at Sound Exchange is about 55%. So If satellite radio loses any of these lawsuits, they are in for a major shock. Now, a question that I'll throw out to you. Do you think that Congress can actually fix this? They can't go back and give copyrights to recordings that came out before 1972, but can Congress fix it another way? And actually, there's an interesting other group of people who are very interested in this issue of pre-72 recordings, and it's archivists and librarians. Because they know that in post-72 recordings, they have certain protections when they make archival copies, that they can make copies of recordings and preserve them and make them available to library, customers. But pre-72, they're not sure they have those rights. They take a risk every time, and probably those are the recordings that need preservation more than post-72. It's kind of a very funny thing. So the archivists and librarians are very interested in this issue and have written extensively on it. The question I have is, could Congress fix this under the Commerce Clause? Could Congress just say, look, under the statutory licensing provisions of Section 114, it's not going to work unless everything is included. If you use it, you pay for it. We're trying to create a one-stop shop where everything gets used, and until something's in the public domain, and it still leads to some very interesting issues. A user, a service like SiriusXM, can't really rely on the public domain until, does anybody know what year? 2067. That's when anything pre-72 is definitely in the public domain. If you're Paul McCartney's grandkids, you're hoping, 2067, we at least have till then to collect on grandpa's works. But it's huge savings for SiriusXM if they win these lawsuits. It'll be interesting to see how it goes and whether or not Congress will try to fix this, both for the archivists and librarians, and for pre-72 artists who are probably, not able to tour anymore. They're obviously a little more elderly. Some of the most, I would think, vulnerable artists that you have out there.
Excuse me,
Yeah.
Doug, would you like to take a 5-minute break and then we can come back?
Oh, that'd be great, actually, if you don't mind.
Whenever's convenient.
Yeah. I can keep going, or I can take a break. What do you guys want to take 5 minutes? Or shall we just?
I'd say take 5 minutes.
Okay, Wendy says take 5 minutes. 5 minutes. Thank you.
So after Tuesday, I will be at Happy Camper, but until Tuesday night, I was just like, this weekend I was just like stressed and because I had to get my notes. I had barely started working on that oral argument. I have to work on that tonight. Yes. What? I hope so. We'll see. I am public speaking, so it's stressful. But, yeah, so it's more stuff. So she wants to practice tonight after this. Well, it's a good time. That's all I know.
Wait, did that just come through? I mean, I just texted you, but it's really hard to living there. 35 seconds.
Really, 30 seconds is about
I expect that to be faster. Yeah, but you were looking at your postage time, so I wanted to.
You didn't do next year.
semester, yeah.
Oh, wow.
I mean, maybe they'll have it again next year. Or I don't know. It's not like I don't have room for it, nor am I just actually take it. It's not interesting.
Yeah, that's really good. Thinking about your seminar dropping one
Not to totally throw off your scheduling, but it's
In fact, there was actually.
and then there was privacy and execution.
Are you doing the conservation activity?
I mean, that's why I wanted to get, somebody
Most of the classes that I'm taking anyway, so it wasn't really too much extra work.
I mean, in all honesty, like all of the classes I'm taking, like outside of concentration, I only needed one more class.
Yeah, that's why I think it's anyway, I might as well take the extra 1 or 2 classes and pop this on my transcript. Then like take them. I'm gonna bring my lunch, eat my lunch. Yeah, until we're and then fry over.
You mean before the meeting? And one of the cases. What, together they take up about 30.
Every like starting a new
A fact. Go on.
Maybe I'll do that next line.
Right, Jeremy?
Probably most of us are going to sleep.
Oh, you were just saying corporate finance, right? I tried to myself a wait list.
There's a wait list now.
Because you worried me, because you said it was only offered in the spring, and I have to take it for the transaction concentration. I'm like, well, I better get into it now. Yeah, because I mean, you need it for that, and I don't want to wait until next spring, and then you know what if it doesn't work out with another class that I need. So I thought I didn't realize it was only offered in the spring. So
That's
I
why
myself
if you
just
do
did
it this year, and then next year I can decide if I can do it or the second.
Yeah, I definitely wish I did all that.
I guess what you were asking about with the copyright rules, are there any statutory transparency provisions that that they would have to that they're required to say who their clients are or any other issues with that, kind of like with patent search. So well, I know with patents you don't necessarily have to do that, and that's a big issue that's going on.
Michael, Jeremy says that from patent troll law, they don't have to say who their clients are. With patent
Certain types of litigation. Sure, in certain types of litigation for patents, there are transparency issues that these patent trolls don't necessarily have to say who their underlying clients are. Because they can hide them in other sorts of corporate. Right. Okay.
All right, we're going to begin again. Mr. Simpson?
Okay.
By the way, he's being recorded as we all are, as I think you know from the camera.
Being recorded. Also, just talk about a couple of interesting statutory issues that are highlighted in some of your handouts. I'm not sure this one is, but there's two different rate standards in the statutory license that these copyright royalty judges have to apply. So in webcasting, Pandora or Slacker or RDO, any of these services that have non-interacting service web streams, Last.fm was one of those for a while. All of the broadcasters who stream online simulcast. The standard that the judges had to apply was essentially trying to find a free market rate. And it was what would a willing buyer and a willing seller pay in a marketplace? Pretty simple, straightforward standard. One of the things that's really curious about it is that this law gets passed in 1995. It's not expanded so much as it's clarified in the 1998 DMCA that it applies to webcasting even if they're non-subscription. But there's this rate standard, and it's a willing buyer, willing seller. What would they pay in a marketplace? The real challenge for SoundExchange, and frankly for the users on the other side, is there's never been a market in webcasting. So how do you reach a free market agreement? What do you use as a benchmark? And there really was only one deal that had been done in the marketplace. I mean, the RAA had, before SoundExchange existed, had done about 40 deals. But pretty much all of those deals were done by a monolithic trade association representing 90% of content at the time, versus tiny little small users. So the judges basically threw all of those out, said, these are not evidence of a marketplace. This is a large party extracting whatever they can out of these small users. But when they got to the Yahoo deal, which was the successor to Broadcast.com, Mark Cuban's company, you had a major technology company and the recording industry. And so that deal actually became the basis for webcasting rates in the United States in 2002. That's how the rates were set. That was as we've gone through over time, how you create benchmarks. It's very creative lawyering. We've had some very great lawyers who've represented SoundExchange over the years. Trying to figure out how to maximize the value to my members. It's really fascinating to watch. And again, we would have economic experts who would come in. We had some guys from MIT, some guys from Wharton, who would come in and talk about different kinds of theories of how we should reach the right price. Now, there was a marketplace of interactive recordings. So you knew on the on-demand service, Rhapsody and obviously later Spotify, but there were a number of those services early on where you could get the song as long as you wanted it, and essentially those services were paying 50% of their revenue for the content. So that was where it started. So our challenge was essentially, okay, if 50% is what you get when it's the song you want when you want it, how much do you discount that when you're just essentially getting streamed radio? And again, we employed experts to testify how we would do this. And it was really quite an interesting exercise. And just by way of example, it wasn't a sound exchange rate proceeding, but one of my favorite cases came out of Ireland, where the Irish authorities thought they were not being paid enough for the use of their music. And so what they did was, they did a cost analysis. Someone would go to a disco, and that person who went to the disco would pay this much money for their drinks, and they'd pay this much money to check their coat. They were paying $1 to check their coat, they were paying $5 for parking, they were paying 50 cents for the music. And it just seemed crazy that you would pay more to check your coat than you would for all the music that was being played at the disco. This led to a six-fold increase in that royalty rate that was being paid by Irish discos. So the attempt has always been try to find benchmarks, try to figure out ways to increase value of return for copyright owners and the artists who are creating music initially. And remember, this is a fair market standard for webcasters and for broadcasters and simulcasts. Now, as I mentioned earlier, there were two standards. There was a separate standard to apply to these organizations, to these companies that already existed, the pre-existing satellite services, PES. And for satellite digital audio radio services, that's Sirius and XM satellite radio. Do we have any Sirius XM subscribers here? No? Okay. Any of you familiar with the service? Been in a rental car, had a parent or something? Okay. Basically, hundreds of channels of content. Howard Stern is there now, he left regular radio to go there. They have public affairs, you get the BBC, you can get lots of different kinds of media, sports, they have the NHL, they have football, baseball, hockey. Not sure why you don't listen to hockey, but it's neat. I'll talk about, I've tried to help hockey. I'm worried about the recidivism in hockey. These guys go into the penalty box, they come out, they commit another crime. I think for three-time losers, we need a death penalty box. It's just my own personal feeling. I'm not a hockey fan. But anyway, for the satellite services, they were launching satellites. They were spending billions of dollars to essentially launch these services. So they were able to lobby and get a rate standard that isn't a willing buyer, willing seller. It's not a fair market value. And it's to maximize the availability of creative works to the public, to afford the copyright owner a fair return for his or her creative work and the copyright a fair income under existing economic conditions. And then it's to reflect the relative roles of the copyright owner, copyright user, the product made available to the public with respect to relative creative contribution, technological contribution, capital investment, cost, risk, and contribution to the opening of new markets. So you can see that satellite radio, because of their massive investment in satellites, was able to get a separate below market rate, because the judges had to take into consideration their capital investment and their risk that they were taking, and as well they had to look at any disruptive impact these rates would have on the structure of the industries involved. And remember, the PES existed before these laws were passed, so clearly there was going to be a huge impact on them. There was going to be a disruptive impact once they had to start paying a royalty they never had to pay before. So, not surprisingly, the PES rate was initially set at 6.5% of their revenue. Any new market service that came into the same space was paying double. So the judges essentially said, for these three companies, because they existed before the law, they're now up to 8% of their revenue. Everybody else is paying 16%. So that is a discount that they've been able to obtain. In the very first proceeding that Sound Exchange had with satellite radio, now, when satellite radio first launched, Sound Exchange was really the RAAA as the predecessor, did a 5-year private deal. It was supposed to be non-precedential, it was lump sum payments, it wasn't tied to a percentage of revenue. It was just lump sum payments, which in a way were very good for the early days of Sound Exchange. We knew we had a certain amount of money each year to help the organization grow and invest in technology. In 2006, when the judges set the first rates, the value of us was enormous. Our income went from $60 million in 2006 to $140 million in 2007. All based on the increase paid to us by satellite radio. So it was a dramatic increase. Now, we felt we were victimized in that proceeding, even though our monetary bump was quite substantial. What happened in that first proceeding was the judge, taking into consideration these factors, said, gee, both of these services are losing money right now. They've invested a lot. They're involved in an arms race against each other. Sirius paid Howard Stern, hundreds of millions of dollars. And, their argument always is, well, Howard Stern's exclusive to us. Music isn't. Anyone can play the music anywhere. So we shouldn't have to pay as much for music as we pay for other content. Our response, and again, the initial 2006 proceeding, the offer that Sirius XM, and they were separate companies, so it was Sirius and XM, but working together in a joint rate proposal, offered us less than 1% of their revenue. We'll give you 0.88% per year. I pointed out that that would be paying us less on a yearly basis for 70 channels of music than Howard Stern's manager was making on an annual basis. Not Howard Stern, his manager. Making 10 or 15% of what he made. We came in asking for 10% of their revenue with escalations over time. And we went in front of this, we couldn't reach a voluntary agreement, we went before the judge. And that first Copyright Royalty Board ruling was that they would have to pay 6% of their revenue. Now what's interesting about the 6% rate that we got is the judge has actually said, well, your value to the service is 26%. Your value of satellite rate is 26%. But because they have 50% of their channels or more are non-music, we're going to divide that in half to 13%. And then because they're struggling, we're going to divide it further down to 6%. But we'll give you a ramp. We'll give you a slow ramp from 6% to 8% over the first 5 years of the deal. So when the rate ran out in 2012, our rate was at 8%. Satellite radio is now a very profitable business. They have about 25 million subscribers, paying about $12 a month, or about $4 billion in revenue this year. There was a new proceeding that just set rates starting at 8% and now escalating up to 13%. So we're finally getting to 13 in 2017, which back in 2006, the judges told us we should be getting 13 then. So you can see that this rate standard has resulted in us receiving far less money. So the rate standard has a huge effect. And because there's a differential rate standard, there's been a huge outcry from Pandora primarily. I mean, they are the market leader. They've got 70 million registered users. You probably get that email from Tim if you're a Pandora listener. We're paying too much in royalties. I would argue that they're paying too little, but we'll talk about that in a minute. But he's upset because there's a double rate standard. And satellite radio gets a more beneficial rate than Pandora gets. To be fair, Pandora never launched satellites and spent $1 billion and didn't risk that. They've invested money, no doubt. They have a lot of people adding to their music genome project. Anyway, this rate standard is in 17 U.S.C. 801B. It's known as the 80B1 standard, as opposed to the willing buyer, willing seller standard that applies to webcasting.
Question.
Yeah.
So you said that the XM and Sirius got it below market rate.
Correct.
But because of the statutory license, there is no free market in these particular sorts of licenses. So how do you call it something below market rate?
It's a good point. I guess because I'm standing up here, I get to say that. No. Well, I think if you looked at, if the judges said Sound Exchange's value to satellite radio is 26% of their revenue, looking at all of the evidence that we entered in this proceeding, and this was an 18-month proceeding with, as I mentioned, thousands and thousands of pages of transcript, lots of expert testimony. We did, for example, just to show you the kinds of things you do, we had an expert from Wharton who did mall intercepts. He basically interviewed people who went in malls and said, do you have satellite radio? And if they said yes, they would ask a series of questions. And what they found out was that 47% of people said if they stopped having music, they would terminate their subscription immediately. And the other 53% said if they keep their subscription, but they only pay half as much as they were currently paying. It kind of drove the point home that music was driving at least half the value of the service. And there were other economic theories that we used with a variety of different economic experts from different institutions. The other thing to remember, it's a limited universe. There's two companies that have launched satellites. They're now united into one. With webcasting, there's there's virtually no limit that there can be with webcasters. Anybody can plug in a computer and start streaming music, take a license. And we do have thousands and thousands of people who do it. Most of them are tiny. I would say the vast majority are non-commercial, either college radio stations that stream online, or what we call microcasters in the sound exchange world, people who essentially pay a $500 annual fee to stream, and as long as they don't hit a certain level of audience, that's all they have to pay. Now, some of the conditions to be a eligible non-subscription service. The conditions are set forth in 17 U.S.C. 114D, 2C, little I through IX. The sound recording performance complement, which is in 114J13. Fascinating. It's the unintended consequences. I think when certain statutory language is written, you have a certain group of people, typically lobbyists, in a room, and they're going back and forth about, how they're going to write the law. All the things they can agree on are probably written pretty well, and then the things they can't agree on are kind of fuzzy. And we'll leave it to a court later to figure out what it really means. And it's just what happens when you can't have agreement. Congress really likes it when everybody's agreed on something and they come to Congress and say, here it is, we've all agreed to it, we love it, pass it, it gets passed. That's the way it works. The performance complement, to me, is just one of those things that, it's an anachronism. It was something that at the time, the music industry thought was really, really important. And that's I talked about this a little earlier, that's the language that says you can only play 4 songs in a 3-hour period by any particular artist. Now, definition of an artist. What I find interesting is on Pandora, if I set up a Beatles channel, in my 3-hour period, I get 4 Beatles songs. I get 4 Paul McCartney solo songs, I get 4 John Lennon solo songs, I get 4 George Harrison solo songs, probably not 4 Ringo songs. You might get one, too. And then you get, other things that are very similar. Concert from Bangladesh, because that's not really George. And, you can see how a service can actually, while complying, probably in spirit, is sort of not really complying in principle. But I think it's kind of foolish anyway. The idea that you can only play 4 songs in a 3-hour period was kind of interesting. Clearly, they were trying to prevent copying and substitution for the actual purchase of recordings. Unintended consequences are always so fascinating. The first call I get on the performance complement, I'm running Sound Exchange, is from NPR. And they said, now, we can't play an entire symphony in a row because there might be 4 movements, there might be 5 movements, there's 6 movements. And if each movement is a separate track, which they are on the CD, and we have to pay for them separately, we can't play them. Now, you can get a waiver of section 114J13 from the copyright owner. So you can go to the record company, and they can give you a waiver, and then you're free to do it. But it just seemed foolish to me that classical music was clearly not even thought about. This was clearly the popular music business that wrote this provision, not thinking that we would be excluding a service from playing. Or, well, I guess you could play movements 1 and 2 by Von Karajan, and then 3 and 4 by Bernstein, and you can get around it that way. Would be kind of interesting, actually. Classical mashups, great. And maybe that's my calling. I'm going to call Girl Talk and see if we can work out a deal. So understand that this, I actually got hired by NPR a year after I left Sound Exchange to help them try to fix this. And they're just waiting for someone to reopen the statute, so that they can get what they want. And, Sound Exchange essentially said to them, we will not sue you if you play an entire symphony. Please, don't worry about it. But, frankly, from a legal standpoint, they were right to be concerned about it. You can also reach out to, there's only a handful typically of classical labels, so it would be easy to get 10 waivers and you'd probably be covered. No advanced publication of playlists. Again, you can see where they were going. This was so that someone could say, these are what's coming on in the next hour, so get your tape recorders ready, and make your perfect digital copies. Limits on archive programming, again, it was a copying, no scanning, which was essentially not to allow service to essentially serve you up the song you wanted when you wanted. This was supposed to be non-interactive, so scanning wasn't allowed. No steps to facilitate copying. They had to display. This was, we thought, a great, consumer issue, which was displaying the artist, the album, the song title while it was streaming. So it gets certain media, you would see who you were listening to. You probably know that on the radio it was a big issue with record companies that radio stations would play things and never tell you who you were listening to. Maybe after a set of 15 songs they'd say, and that was, but if you heard something you really liked and then you stopped at the grocery store and you had to get out of the car before they told you who you were listening to, who was it? So this was always a big thing. And when we actually went to radio stations in the 1990s and said, hey, would you please, we had a campaign called Say It When You Play It. It was to actually announce every single song. Clear Channel, I think, among others, said, oh, well, if you want to pay us, we'll do that for you. This is how much it will cost you. And it was like $20-something thousand a title. To do this. It was like, wait a minute, we own these recordings. You're going to actually charge us to tell people who they're listening to. So this was a major piece, and actually a good part of the piece. But this one, this gets passed in 1995, and 4 years later, no one is going to steal music, taping internet radio, because now you have Napster, you have LimeWire, you have Grokster, you have all these other services. So it was kind of interesting to me that we didn't just, that provision here. So the sound recording performance complement, something that really didn't mean much, though it still exists. I think it will go the way of all things when Congress overhauls the copyright law that we've been hearing registered law they talk about. So that's the willing buyer, willing seller. That standard is 17114 F2B. That's the F2B standard. There's also, as I mentioned, a lot of Copyright Office regulations that govern Sound Exchange and how and what the services have to report. That's all in the CFR, 37 CFR. You can find it in 261 and 262, depending on the year. So I mentioned, rates and terms. I don't know that we'll go through those today. But you can find them on the Sound Exchange website by license type. But I think one thing is kind of interesting. When we first started out, there was one rate set by judges, right? Now, rate for satellite radio under the rate standard that they had, and a rate for pre-existing services under their rate standard. All webcasters were treated the same. That was in 2002. There was an arbitration panel that said everybody pays 7/100 of a penny. It's a lot of money every time you stream a song. 100 people listen, an artist gets 7 cents. It's a lot of money. But there were a lot of non-com stations and college stations that we can't afford that. We need a non-commercial rate because we're not selling ads and we don't have a way to make money. And remember, we had a very interesting universe back in the early days. The web has changed so dramatically, but you had those walled gardens, AOL, you had Yahoo, you had Microsoft, trying to lure you in with music and then get you to shop, get you to email, get you to do all sorts of things on their sites. They didn't want to share any of the income from their sites with the artists and the labels. And it made it very tough for us. What's the revenue definition if they were going to pay us a percentage of revenue? We finally couldn't agree on one. We could not agree on a revenue definition, which is why the per stream rate became the de facto way we measure what people should pay. So we had one category of webcaster. That changed in 2003. Sound Exchange kind of voluntarily, even though the arbitrators didn't give us this, we said, well, NPR and non-commercial, educational, and religious, there should be a separate rate. And so there was crafted with the arbitrators in a settlement. A separate lower rate was quite substantially reduced. But that still didn't address small little webcasters who didn't have other businesses like AOL and Microsoft that weren't the multiplex services, the walled gardens. They went to Congress in 2003 and there was separate legislation called the Small Webcaster Settlement Act of 2003. And what that did was to say any small service that's under $1.25 million in revenue or in investment could pay 12% of their revenue. It was actually 10% up to a certain amount, 12% above that, up to $1.25 million, and then they had to graduate to become a large webcaster. That was 2003. It was the first time we had a second commercial webcasting rate. And what's interesting, though, in that same legislation in 2003, a much more significant change occurred in the law. Before 2003, if you read the law, and I have to tell you, this was really a light bulb moment for me. I had lobbied to get the law passed in 1995. And remember, I never thought I'd be running Sound Exchange. I never thought I'd have anything to do with collective management of rights. I was managing artists. I thought I'd be managing artists or running a label or publishing company. I was in the transactional music industry. So I didn't pay attention to what the law actually said. I just wanted to get the right that artists and labels had a right to get paid. So now I get recruited to outreach to artists and independent labels as part of this collecting society that's being created. And I read the law. And in the law, it actually says that when the collecting society collects the money, they're going to take their costs off the top, right, our administrative fee. Then they're going to take 5% and send it out to California to a fund that's administered by two unions that look after vocalists and musicians, AFM and AFTRA. And those two organizations are going to take the 5% and they're going to distribute it to all of the background musicians, all of the people who sang on those recordings that you wouldn't know, and the people who played on the recordings. So it was a very lovely idea that people who got paid a set fee, probably $150, $200, $300, to play on a record that became a huge, massive hit, would actually have some continuing payments, even though it was small. By contract, 5% of the total, or 10% of the artist's share, let's say. In France, the background musicians get 50% of what the artists get. In the UK, it's about 35%. So the United States having a 10% rate for background is pretty low. I wasn't involved in those negotiations, so don't blame me. But what it said was, so 5% is going here, the 95% is going to be paid to the copyright owner. That typically means the record company, because typically the record company owns the copyrights. Then the record company is going to allocate 45% of the money to the featured performer. I had always thought, like ASCAP and BMI, who divide the money 50-50 between songwriters and music publishers, that this collecting society was going to do the same thing. 50% to the artists. There's obviously the split between the featured and the non-featured, and then 50% to whoever owned the copyright. No, 95% was going to the copyright owner, who was then going to allocate. I called up some of my union friends. I said, allocate doesn't mean pay. If an artist hasn't recouped the investment, all those advances they get for videos and recording budgets, they'll never see any of this money. And they said, oh, no, allocate means pay. I was very upset. I was very worried about this because I realized that this would just undermine completely the legitimacy of the organization if they weren't actually making payments direct to artists. Artists were used to this through ASCAP and BMI dividing the money the way they did. In the 2003 Webcaster Settlement Act, the artist side of the Sound Exchange Board was successful in getting the law changed to say that 45% would be paid directly to the artists. So there's a little interesting side note. The artists actually got direct pay anyway in the first couple of years of Sound Exchange because of a misstep by the major labels. And that was a very big blow up in 1999 and 2000. Have any of you ever seen a record contract? Anybody here? Interesting, okay. In every record contract, and I've negotiated quite a few for artists over the years and actually signed my own in 1971. Actually 1970, I signed my contract. In every record contract, it says, almost every record contract, this is a work made for hire. And if a court of competent jurisdiction finds that it isn't a work made for hire, well, then this is an assignment of your rights. So it's a bootstraps argument, obviously. They're hoping it's a work made for hire, these record companies. They want to own it. If it's a work made for hire, they own it. They are the owner from the outset. The term is 95 years that they get to own your work. But if it's an assignment under the 1978 Copyright Act, I can get my rights back after 35 years. So they don't want it to be an assignment. They want it to be a work made for hire. Every contract said that. But if you go and look at the statute, and I think Wendy's handed that out, if you look at the work made for hire language, there is nothing in the statute that would lead you to believe that a sound recording could be a work made for hire under the definition. It's just not included there. Now, record companies have tried to maintain, oh, it's a compilation or it's a collective working, we're going to be fine. Right? Now, you're a record company. You know this language. You know that you have a major vulnerability remember, 1978 is when this right of reversion at 35 years gets passed. The right of reversion, 35 years in 1978 is 2013. Very interesting that we're in this year right now. This is the first year when artists have the right to recover their recordings from record companies that were released in 1978. There are quite a few artists who have sent notices to their record companies that they want to recapture their rights. They had to provide a notice 2 years in advance, or actually even more, they can do it within 2 years. But what was interesting is the record companies, I think, in 1999 started to panic a little. They started to get closer and closer to 2013. And they weren't sure they could win on their compilation and collective licensing argument, collective work argument. So what the record companies did in the fall, November of 1999, was they inserted language into an omnibus bill. It wasn't even about copyright. Well, it was about satellite retransmission. But it wasn't about music. And what they inserted was 4 very tiny words. It basically just said, sound recordings are now eligible to be works made for hire. And they told Congress, and this fellow who inserted the language, this was a technical amendment. Really didn't change things. Because artists have been signing contracts that have said their works made for hire since the beginning of time. Well, at least since 1972 when they got a copyright. So I think there were those on the Hill who thought this really was a technical amendment, that we're just putting in language that really reflects the custom and business in the music industry. It was inserted and passed, and when the artists found out about it, there was no debate, there was nothing about this before it was inserted. The artists find out about it when it becomes law in February, and there is a huge hue and cry. There's this major outrage that the record companies have tried to essentially, under the cover of night, in an omnibus bill, stolen these rights from artists. And to make matters worse, the guy who was the counsel to the House Judiciary Committee, who inserted the language, gets hired by the recording industry to be their new legislative counsel at about 2 or 3 times the salary he was making when he was working on the Hill. So it really looks awful. Looks really, really bad. Now, for me, coming from having represented artists my whole career, this happens 2 weeks before I'm supposed to start working at the RIAA to launch this new organization. It couldn't have been the worst time. I'm like, can I even take this job now? I'm supposed to do outreach to artists, on behalf of this trade association that's just trying to totally screw them. It was very, very difficult. What happened was all these artists came to Washington. There were lots of hearings on the Hill, incredible negotiations, and one of the most amazing things is that the record companies realized right away they were going to have to give in and have this repealed, or have it removed from the statute. So the negotiation was really over wanting them to make sure that it didn't have any precedential value when a judge in 2013 was determining whether sound recordings were collective works or compilations or somehow fit within the work for hire definition. Like, we didn't really need to have this language. We just inserted it because it was, it's the middle of the night, we didn't have anything else to do, So they clearly were caught, and they didn't know what they were going to do. And if you read page 2, it's very interesting. I mean, you will almost never see something like this.
Definition of work for hire is at the bottom of page 2, and
Here we go.
the magical disappearing amendment for sound recordings is in Courier type on that page.
So in other words, we're never enacted without regard to any inaction or list of Congress at any time of any judicial termination. So basically, we're trying to say, we just don't want anybody to be able to consider this, that we did this. when they look back at this in 2013. Another thing that I think is just kind of an interesting issue, and it's part of your handout as well, is Sound Exchange was tasked with paying the featured artist. And I guess the question is, who's the featured artist on the record? Really interesting question. Who's the featured artist? There were almost several legal actions. None ever got filed. One of the first issues was, who do we pay when we're paying a symphony? Who gets paid by Sound Exchange when it's the New York Philharmonic with conductor Michael Tilson Thomas, with special guest Itzhak Perlman? Am I dividing the money in three ways? Michael Tilson Thomas gets a third, and the New York Philharmonic gets a third, and Itzhak Perlman gets a third? Maybe. That sounds fair, I think. The symphony called us out. Symphonies, San Francisco Symphony, Philadelphia Symphony. That money should go to the management. Whatever share is being given to the symphony should be paid to the management of the symphony orchestra. We have deals with all the musicians. They're the non-featured performers, and they should be paid through that 5% fund. And I said, no, that doesn't make sense to me. The symphony is the 90 players or 100 players or whatever it is. It's a lot harder for me to make 100 checks than to send one check. But I just felt like this is a line in the sand that I wasn't going to cross. And I said, no, it's the musicians in the symphony. And so we held firm to that position. We were threatened by a couple of the symphonies that were going to sue us. No one ever did. But again, it's kind of a fascinating issue. When we looked at the legislative history, and I've learned long and hard that sometimes legislative history is actually created for various reasons rather than it's just history. This is interesting language in the legislative history of section 114J7. The term featured recording artist means a performing group or ensemble. Let's see. For example, the Eagles would be the featured recording artist on a track from an Eagles album that does not feature Don Henley by name with equal prominence. But if the same recording were performed from Don Henley's greatest hits, then Don Henley and not the Eagles would be the featured recording artist. I said, really?
From the legislative history.
This is from the legislative history, and I was sitting there going, okay, so if Peaceful Easy Feeling or Desperado is played on an Eagles' greatest hits, I'm paying the Eagles. But if it's played on a Don Henley's greatest hits, the same guy's playing on the record, I'm not paying Don Henley. Made no sense to me. And I basically said, legislative history, forget about it. We're going to pay the artists, the featured, whoever played on the recordings. Now, Sound Exchange had a really interesting issue, and basically it was finding out how the artists want us to pay them. Now, some bands like the Eagles have Eagles Limited. It's a corporation. It's very easy. We send Eagles Limited the check, and they distribute it among the various members who played on the various tracks. And remember, when Sound Exchange collects money, every single track is reported to us. So it's not like a lump sum payment. Oh, we have $50,000 for the Eagles. We have 32 cents for Peaceful Easy Feeling. We have $1.39 for Take It Easy. We have $4.77 for Witchy Woman. So we have it by track. And so the business managers, or the lawyers who represent the corporation, get it on that level and know who played on those tracks. And so what you have to realize is that Fleetwood Mac in 1969 is totally different than Fleetwood Mac in 1975. Different members of the band, different people getting paid. It's a massive amount of work. And I mention that because one of the problems we have in this business, there is no global database of repertoire. There is no global database of who owns what. There is no global database of who the performers are. Now, there is a database in Europe. It's called the IPDB, the International Performer Database, that a number of collecting societies have endeavored to create. It has some pretty big holes. The United States just joined recently that effort. There's a couple of other databases that are out there, but there's no all-encompassing database yet.
Finish that.
Oh, there's no all-encompassing database that tells you who owns what in which territories, because frankly, some sound recordings are owned by Geffen, now it would be Universal in the United States, and they're owned by Warner in the rest of the world. There were artists who did that. They would parcel out their rights to certain recordings in different territories because they made more money that way. But you have recordings that are owned by different people. We have another issue that came up earlier, which is in Europe, the sound recording copyright was 50 years. It was just recently extended to 70 years. It was effective in 2012, and the reason it was effective in 2012 because 50 years from 1962 would have meant the Beatles would have gone into the public domain in Europe, and the British weren't going to let that happen. So they've got another 20 years to exploit Beatles recordings. The copyright term for the Beatles is, for everybody, is now extended to 2032. There were some wonderful things included in that extension, like use it or lose it clause, so artists can get the rights back, background musicians get a bigger chunk of the money, and any unrecouped balances by artists are wiped out. So it's nice that we get 20 more years, but what's happened in the past, Elvis is in the public domain in Europe, all those great recordings in the 50s. There are companies in Europe that manufacture, don't have to pay Elvis or his estate, and they send those recordings here to the United States where there still is rights that are owned by RCA, BMG, which is now Sony again. So we have gray market import problem here in the United States. So we do need a harmonization of term. Maybe we should just make all copyright terms, infinite, and that would solve everything, right? No? Not even? Yeah, did you have a question?
No, yeah.
Okay. So, you can imagine not having a database that tells you who owns what. It was a massive problem for Sound Exchange. Now, think about ASCAP, BMI, and CSAC on the musical work. In order to get paid by those companies, you have to register. You have to sign up, tell them what you own, and then they pay you for what you own. In the United Kingdom, if you want to get paid by PPL, which collects for sound recording copyright owners and artists, you have to register. You have to sign up, tell them everything you own. PRS, their equivalent of ASCAP, BMI, and CSAC, they have one PRO on both sides. One for the songwriters, one for the recording artists. PRS, you have to register everything you own to get paid. The very first collecting society that I'm aware of that basically was told, pay everybody in the world and no one has to register, go find them, was Sound Exchange. So it was a massive undertaking that we had when we first launched. And you can imagine you're breaking the back of years and years of data, trying to find tens of thousands. I mean, think about it now. Sound Exchange now has 98,000 artists signed up. 98,000, 28,000 rights owners. I think, in the first year we might have had 10,000 artists and maybe 1,000 rights owners. And again, some of it was people didn't even understand that they had a new right to collect. I would talk to managers in the music industry and say, hey, your artist now has the right to get paid from satellite radio from there. Oh no, we don't have a performance right to that. There was such ignorance. If Congress is going to pass a compulsory license, maybe Congress also needs to put aside some money to educate people, to let them know that there's actually a new right. People can use their stuff. I mean, I would get people calling me up. I remember getting called up by an artist, a major artist, screaming at me. Who gave me the right to license her stuff? I said, actually, Congress did. And once she found out that I actually had a check for her and I was going to send her a nice check, she was very happy. She loved me after that. But the sense that someone could take your stuff and use it without your permission was very interesting, and we did nothing to educate people about it. Clearly, we didn't have any money to do this. So, you can't afford, you can't expect a brand new collecting society with no resources to spend that kind of resource. Congress needed to do it, but they didn't. So it was a fascinating journey. It's been very interesting, and let me just say, my first year running Sound Exchange, we collected $3 million. Very modest. 2010, when I left Sound Exchange, we collected $263 million, and we knew that we were going to collect about $350 in 2011, the year that I was sort of consulting and helping them with the transition. This year, it'll be $650 million. So all of a sudden, we have this very important revenue stream for recording artists and labels. Yeah.
We're about to end, and there's one crucial question
Yes.
remaining. How did this affect the revenue stream of the musical work copyright owners?
It's a good question. For years, the broadcasters especially had said, hey, we're happy to pay performers, but there's a pie. And we don't care how you divide up the pie. They were really trying to play the songwriters off against the recording artists by saying, we have a fixed amount of money that we're willing to pay. And if you think about broadcasters for a minute, the pie theory that they've tried to, push forward, they pay 4% for the musical work. That's about what they pay songwriters. They pay 0 to the recording artists. 4% for the main content that you use seems awfully small to me. There are many businesses that pay 60 to 70% in content costs for their business. Certainly, internet radio and satellite radio pay that kind of content cost. So, very interesting. We have seen no reduction in musical work. However, I will say, where Sound Exchange is collecting from Pandora and from satellite radio, we get far more than they do. So they're not getting less than they used to get, but we're getting more. And the question is, are the recording artists and the record companies who invest in making recordings and typically investing far more, should they be getting more? And if they should be getting more, what's the right factor? I think the balance right or the imbalance at Pandora is way too wide. Because sound recording, copyright owners, and artists are getting about 14 times more than the songwriters get. It's usually more like 5 to 1. Sometimes it's 3 or 4 to 1. 14 to 1 is pretty extreme. And that's for another day, talking about why that imbalance exists. But I don't think we've seen what everyone was worried about, which was that by giving recording artists a right, songwriters would suffer. The money that they're collecting on the musical work, as I mentioned, Sound Exchange will collect $650 million because they have broader rights from more sources. This year, the performance right on the music, on the composition, will be worth about $2 billion. So 3 times what recording artists get in total.
I think we're about.
Are we done?
Time.
Any questions?
Yeah.
I'd like to express our appreciation.